Hi, everyone, and welcome to our next two cases that are being presented together in one assignment. Why? Because they're both relatively short opinions. There are no concurring or dissenting opinions in any of these cases, and because they're a natural sort of pair, because they both involve economic regulations designed solely to benefit women, female workers. So, again, in both these cases, just like every other time, you need to know the facts, the issue, the holding, the reasoning, the rules, and what theories of interpretation do you find in the reasoning. Okay, so let's start with Muller versus Oregon. Who was Muller? Hans Muller ran a laundry in Oregon in 1908, so we're talking about just a couple of years after Lochner. And as it's stated in the opinion, he employed Mrs. E. Gotcher. Her name's Emma, but, in the male dominated world of the judiciary, it wasn't even worth writing her first name out in the case, which. And then, of course, it completely overlooks the fact that at 16 years old, she's married and is working. But I think what we should be focusing on is how remarkable this young woman is because, despite having to work at the age of 16, she's already a union leader. And so Mueller was fined $10 for having Emma work more than the allowed number of hours. So in a way, because these laws regulate work hours, this case is kind of similar to Lochner. However, the Oregon law only applies to women, and there was only an hour per day limit. There was no hour per week limit. But the New York law only applied to bakeries, hence Bake Shop Act. The Oregon law applies to women working in any kind of factory or in laundries. So in the vast majority of settings in which a woman could get a job in those days, leaving aside working as a maid in someone's home. So the issue in Mueller versus Oregon is whether a state law regulating work hours for women infringes on the liberty of contract in violation of the Due Process Clause of the 14th Amendment. And you get a unanimous decision. But the same sort of conservative Supreme Court that issued Lochner, they're going to come out the other way in this case because gender differences justify protective legislation regarding work hours. And there, it looks like there are arguments about two other parts of the 14th Amendment, the Privileges or Immunities Clause and the Equal Protection Clause. They're not the reason why this case was assigned. They sort of drop out. You don't need to know anything about that. So, how did Mueller fall short and the law ends up getting upheld despite what he argued? So his main argument was that the government had picked sides and had favored workers at the expense of whoever was employing them. It had an obligation to stay neutral. And by picking one group over another, the government was engaging what's called class legislation, favoring one group at the expense of another. And then, separate from the choosing sides, there was an argument that this just wasn't a valid police power regulation because there were no health or safety interests in this one particular case. Because laundromats, he tried to argue, were not particularly dangerous. And so, therefore, there's not a strong enough connection between what the law actually does and its goal of protecting women's health, because if laundromats are not a dangerous place, there aren't any health risks, right? So how did the court end up dismissing those two arguments? Well, they relied on science, specifically a brief submitted by Louis Brandeis, who went on to he was a lawyer at the time, working for the National Consumers League, which is still a major organization today. But Brandeis went on to become a Supreme Court justice and a legendary Supreme Court justice. But he submitted this brief in this case on behalf of the state of Oregon. So even though he worked for the National Consumers League, he got hired by Oregon to represent them by the Supreme Court. And he basically wanted to make sure that they didn't repeat Lochner's mistake. He wanted to make it perfectly clear that the interests of women really were at stake. And there's a reason why we should put quotation marks around the term Brandeis brief. It assumes that Louis Brandeis was responsible for what's written within this book cover. It's not true. It really is Josephine Goldmark's brief. She was more than an assistant. She wrote 90% of what was inside, or at least oversaw the research gathering of 90% of what was inside. So Josephine Goldmark was Brandeis's sister-in-law. She's a remarkable woman in her own right. Here she is. So Goldmark, before the days of Google, if you wanted to find out facts, you go to a library. And so she set up shop in the New York Public Library for a month, doing all sorts of research on the dangers to women's health and safety. She looked through countless reports of factory inspections, and she looked at what doctors were saying about women working. And she also came up with a list of laws across the country and around the world that protected women in the workplace. It was a really, really remarkable thing. And it was also kind of unique. So we might also put quotation marks around the word brief, because brief implies short. Normally, when you submit a written brief to the Supreme Court, it's 35 pages. But it's all about legal arguments. And you might say, well, 35 pages sounds like a lot. Yeah, well, the Brandeis brief had 202 pages of legal arguments and then 98% or 98 pages worth of social science stuff, all of which was done by Goldmark and her team of female research assistants. The Brandeis brief was not Brandeis, nor was it brief as in short. And it actually wasn't even a single brief either. They did similar writings on other progressive economic issues. There were a series of briefs produced by the National Consumers League around this time. So here's what it looked like, right? And so, the dangers of long hours, bad effects on safety and morals. So, it's scientific, but they're trying to relate it to legal concerns about public health, safety, welfare, and morality, right? This is very rare to, in a Supreme Court decision, shout out one of the lawyers in the case for really doing his homework, right? If you saw the majority opinion, that Louis D. Brandeis gets a shout out, not Goldmark, unfortunately, but So these sort of help the justices provide an answer to Mueller's arguments. So on the one hand, liberty of contract is not absolute, and a state may, without conflicting with the provisions of the 14th Amendment, restrict in many respects the individual's power of contract. That's the rule in this case, right? So the only question is this one of those legitimate times in which you can restrict your power to be completely in charge of your economic situation? The justices end up concluding the state of Oregon is justified because they think basically women are frail. Not because that women are frail on their own, but the potential for women to overexert themselves at work means that they would be unable to perform their maternal functions. And so basically, the state of Oregon is justified in protecting women in the workplace so that they can become mothers and be mothers, which, is that's why I've got the discussion board post written the way it is, because on the one hand, women are getting the attention from elected officials. This is before they had the right to vote. They're getting steps taken to regulate poor working conditions. But on the other hand, the justifications upholding these protections are very sort of traditional, gender ideas. So the court says healthy mothers are essential to vigorous offspring. The physical well-being of a woman becomes an object of public interest. So yeah, for better or worse, that's how the court interpreted all that scientific evidence. Um, and then there was another argument about is this about there's another passage in the opinion where we should take a step back and question the reason why it was written. Um, so uh, the the majority opinion says that education was long denied to women. And while now the doors of the schoolroom are opened and women's opportunities for acquiring knowledge are great, yet even with that and the consequent increase of capacity for business affairs, it is still true that in the struggle for subsistence, she is not an equal competitor with men. Women aren't equal with men. So, I mean, look, there are one of two ways that you can interpret this passage. One is that it's just sort of stating a fact that opportunities for women are getting better, but they're not equal. Um, or another way of understanding this is like the justices just have sort of misogynistic views about women. Because you might say, well, what the justice really meant was she's not an equal competitor and she never will be, despite the fact that she's getting more, like women are getting more opportunities than they used to have. Given the maternal functions stuff, I don't think it's completely unreasonable to read a little bit of misogyny into this statement. But I don't know. It's something that you guys can figure out for yourselves. And then the other response was, Mueller was like, oh, this is class legislation. You're picking sides. And the court's response is, yeah, we are. And that's okay. Right? Differentiated by these matters from the other sex, women are properly placed in a class by themselves, and legislation designed for the protection of women may be sustained even when, like legislation, that is not necessary for men and could not be sustained. So that's how you differentiate this case from Lochner. Okay, so again, I hope this helps. Again, if you have any questions, make sure you're using the perusal to ask them. But now it's time to move on to our next case, and that's Adkins versus Children's Hospital. And this takes place a couple of decades after Mueller, and it's a case originating from Washington, D.C. Um, and um, and yet, so here's the weird thing: the District of Columbia is part of the federal government. It has a city council and a mayor and all that kind of stuff, but only because Congress allows it. And so you might reasonably ask, okay, if this is a case involving a federal law applying in the District of Columbia, is this case going to be about police powers or enumerated powers? And the case, believe it or not, comes down to police powers, despite the fact that in every other instance we say that for a federal law we have to point to one of the enumerated powers of Congress. Why is this the exception? Because someone has to protect the health, safety, welfare, and morality of the people in Washington, D.C. And the Constitution says that the entity of government that's in charge of that geographic space is Congress. And so Congress, in this one particular instance, has the police powers. Now, they've kind of delegated those police powers to the city council and to the mayor's office. But Congress could take the city council and the mayor's office away from D.C. if it wanted to. And it has restricted the power of D.C. government in the 1990s after the then mayor got arrested smoking crack with a woman who was not his wife. It happens. This is a minimum wage law that only applied to female workers in the District of Columbia. And then the Children's Hospital and a female employee sued Jesse Adkins, who was a part of the agency that was set up to administer the law. Why would a female employee object to being paid a minimum wage? Who knows? People do all sorts of things for clickbaity kinds of reasons, and That appears to be what happened in this case. Um, so, what's the issue? It's whether a minimum wage law for women in the District of Columbia violates the Due Process Clause of the Fifth Amendment. Why the Due Process Clause of the Fifth Amendment and not 14th? 14th Amendment says no state shall. The Due Process Clause applies to Congress, as we learned in Barron versus Baltimore. But the difference isn't going to matter at all. And whether it was the Fifth Amendment Due Process Clause or 14th, the reasoning is going to be the exact same. You had one justice who was off the court or had recused him or herself. I don't remember the reason why, but you still have enough votes for a majority. So Justice Sutherland writes that gender differences do not justify protective legislation regarding wages. So work hours, Mueller, fine. Wages, Adkins, not fine. You really need to know that for the exam. So let's dive into some of his arguments. That protective legislation designed to protect a vulnerable group is fine, so long as that group actually really needs protection. So here's how he sort of distinguishes Mueller in this case. In view of the great, not to say revolutionary changes which have taken place since Mueller versus Oregon, that Sutherland says, in the contractual and political status of women, culminating in the 19th Amendment, it is not unreasonable to say that these differences between men and women in the enjoyment of civil rights have come almost, if not quite, to the vanishing point. In other words, if women are treated by the Constitution as being equal enough that they're entitled to the right to vote, they're entitled to the same rights to control their economic destiny as the manly men do, who are bakers. And now we might restrict women's rights when it comes to work hours, but they should have the right to negotiate their own salary. That's the argument. If you trust them with some constitutional rights, like the right to vote, you have to bestow all constitutional rights on women, and one of them is to, be completely in charge of, or at least as much in charge as allowable of your own economic decisions. And I think also sort of implicit in this is that the reasons for government to involve themselves with women's issues used to be higher, because before having the right to vote, women were viewed as basically the equivalent of children. Why aren't children allowed to vote? Because they're viewed as too immature. And believe it or not, for most of American history, women were viewed the same way. But now that's no longer the case. And so not only do we treat women as mature enough to vote, according to Sutherland, we should treat them as entitled to economic rights as well. And so if you're looking for reasons why the government can intervene with protective legislation, it has to be about physical differences. So physical differences must be recognized in appropriate cases like work hours, not wages. And legislation fixing hours or conditions may be properly take them into account. We cannot accept the doctrine that women of mature age may be subjected to restrictions upon their liberty of contract, which could not be lawfully imposed in the case of men under similar circumstances. So it's not only unfair to women by sort of denying that they are entitled to freedom of contract. It's even worse. Sutherland ends up saying this law is basically forced charity, that the business owners are being forced to give female workers more than what they are truly worth. Because he says wage is not the value, under this law, the wage is not the value of the service rendered, but the extraneous circumstance the employee needs to get a prescribed sum of money to ensure her subsistence. And instead, if the government stays out of things, that allows people to be compensated to the degree to which their skills are valuable, not an arbitrary sort of floor set by the government. That's a really sort of hardcore, libertarian argument. But there were enough sort of conservative justices on the court at the time that argument got 5 votes. So yeah, and then he sort of, here it sounds this is a naked giveaway to women, right? And But then he takes the argument and it goes even sort of more bizarre. He's like, well, if we uphold a minimum wage, then we are giving state governments and the District of Columbia permission to set a maximum wage. And that's not fair to women workers. If we were to stop someone who's really, really bright from earning more money than they're worth. And it's like, yeah, but no one ever passes maximum wage laws. Governments pass minimum wage laws. Why? To ensure that people who work can exist, to ensure subsistence. But yeah, no, he was really worried about setting this precedent to pass this law that no one would favor. So yeah, that's the essence of Sutherland's opinion. And I'm sorry, I misspoke earlier. There was a dissenting opinion in this case, but they're both pretty short. So Holmes, who dissented in Lochner, is going to dissent in this case too. And to Holmes, he says, like, this is easy. Like, payment, how much money you take home, is a combination of how much you make multiplied by the number of hours that you work. And in Muller, we already know that this part of the equation is constitutionally permissible. And he's basically like, I don't understand how this part of the equation is unconstitutional. I confess I do not understand the principle on which the power to fix a minimum for the wages of women can be denied to those who admit the power to fix a maximum for their hours of work. The bargain is equally affected whichever half you regulate. We've already, limited. We've already kept values of this variable low. So shouldn't we ensure like a decent minimum wage so that the total amount of money that women take home is enough? To Holmes, he's like, yeah, if a majority of people in a legislative body want to try that, that's perfectly fine. And then if you were skeptical about the 19th Amendment argument, that's okay. So was Holmes. It will need more than the 19th Amendment to convince me that there are no differences between men and women or that legislation cannot take those differences into account. And that he's not going to stand for that charity argument either. To Holmes, he's like, this law does not compel anybody to pay anything, right? Because it doesn't force you to hire anyone, right? It simply says that if you do hire someone, you cannot pay them at a rate below those fixed as the minimum. And that minimum is tied to the requirement of health and right living, because you have to have enough money to buy food and keep a roof over your house and all of that stuff. So a little bit more about the National Consumers League. Obviously, they were really happy after Muller, but they were not at all happy as to what happened in Adkins. They called a conference. I love this, right? That like, here's mean old Justice Sutherland, and the caption is, "This decision affirms your constitutional right to starve," and the that says, actually I don't know what that says, but yeah, obviously the woman here is not very pleased by that. And so, the National Consumers League tried to sort of rally public opinion against this. Okay, so what might make fair short answer questions on the exam? Compare the two cases. How in these two cases combined, how does the court, and it's basically the same justices, how do they view women on the one hand versus the male bakers who brought the case in Lochner? And then again, you gotta understand, like, Adkins is about wages, Muller is about hours, and you have to understand the reason why the court viewed those two issues differently. And then I think it would also be helpful to understand a little bit about the Brandeis brief. I should have put the quotation marks here again. I apologize. Why did it work? Why was that a good tactic? So that's all I got. Relatively short. I hope you're enjoying these cases. I hope you're asking questions. And I'll see you next time.